The Public Accounts Committee was a tripartisan committee which consisted of members of the government, the Liberal Party and the Greens. The three members of that committee unanimously have rejected the CTP bill proposed by the government. That's a recommendation which the ALA particularly welcomes. The bill has been rejected by the Public Accounts Committee in its report, principally because of the prejudicial effects that the bill proposes in relation to the ACT motorists. The effect of the CTP bill is to remove the right of motorists who are injured through no fault of their own to claim for non-economic loss. That would be a highly prejudicial removal of the rights of motorists of the ACT, and that's been recognised by the Public Accounts Committee. There was insufficient evidence given by the proponents of the bill, which is the ACT government, that the effects of the bill would achieve the results that the government had stated. The government had stated that the effect of the bill would be to introduce better and more timely medical treatment. There is nothing in the bill which does that. The government also had sought to introduce the bill ostensibly to increase competition in the ACT market with a view to decreasing the premiums paid by motorists in the ACT. The findings of the committee were that there was nothing which would guarantee that the premiums would be reduced, and in fact it was the evidence of the ACT Treasury officials that the premiums would not in fact be reduced by this bill, but they had now merely hoped that the CTP premiums would be arrested. The Public Accounts Committee found in their report that there have been a number of improvements made to the CTP scheme since the regulatory changes were introduced in 2008. They found that the claims frequency has fallen. They found that there has been a decrease in legal costs paid in relation to claims. It's estimated that's a decrease of approximately 27% since 2008. They found that matters are finalising at a much faster rate than they were prior to the 2008 regulatory amendments. They found that the average size of claims has decreased. They have found that there has been downward pressure placed on premiums paid by ACT motorists with respect to the CTP scheme. And most importantly, the 2008 regulations have introduced the early payment of medical expenses. That system did not exist before October 2008. Since October 2008, injured motorists have been able to avail themselves of early, no-fault medical assistance if they make a claim within 28 days. As part of the suite of changes the government have proposed in relation to their 2011 bill, they have claimed that there will be more medical treatment and more rehabilitation treatment made available under the new bill. This is a fallacy. There is no provision within the bill for any increase in treatment expenses or any increase in rehabilitation expenses. Those entitlements were created in 2008 with the introduction of the 2008 Act. There is nothing in the 2011 bill which extends that or makes any further provision for the payment of medical, hospital and treatment expenses beyond that which is already being paid. They have recommended that the 28-day time frame be extended on a discretionary basis because a lot of motorists are still not availing themselves of that 28-day time frame, and it hasn't been sufficiently advertised by the government as an entitlement that people have. The Public Accounts Committee has recommended to the government that a consultative group be established in relation to all stakeholders who are affected by the operation of the CTP Act. Those would include health professionals, motoring bodies, government and Treasury officials, people involved in the legal system who provide services to injured motorists, to review the scheme, to make recommendations as to how it's been improved. This is an approach in particular which the ALA adopts, and we would welcome the government establishing a consultative group in accordance with the recommendations of the Public Accounts Committee. We understand that the government has not yet responded to the findings of the Public Accounts Committee, and they need to say, we accept the recommendations in part or in whole, or we reject those recommendations. And to the present stage, the government has not indicated whether or not they are prepared to accept any of the recommendations of the Public Accounts Committee, notwithstanding that a government member was one of the unanimous supporters of the Public Accounts Committee finding. The Australian Lawyers Alliance, in conjunction with the ACT Law Society and ACT Bar Association, have written to the government indicating that we have adopted and recommended the findings of the Public Accounts Committee. To the present time, we have received no response from the government. The government have proposed to introduce a further bill which we have not been consulted in relation to. It is particularly disappointing considering that the Public Accounts Committee has made a finding in relation to this matter and that the government has simply not responded to the Public Accounts Committee at this time.